Já faz algum tempo que a realidade virtual não é mais uma ficção restrita aos divertidos simuladores de parques temáticos. A chamada gamificação invade todos os campos da experiência prática. Mais e mais, objetos virtuais se somam à experiência prática concreta de todos nós. A realidade aumentada é o novo normal. Seu propósito é facilitar a nossa vida cotidiana, enriquecê-la e diversificá-la. Nesse mundo, há objetos virtuais que cumprem rigorosamente as mesmas funções que os objetos materiais cumpriam no passado. Maçanetas e chaves virtuais abrem e fecham portas. Carrinhos de compras virtuais carregam produtos que são pagos em caixas registradoras igualmente virtuais. E os produtos reais chegam às nossas casas, depois de pagos com reais, subtraídos de nossas contas reais por meios virtuais. Na linguagem técnica das tecnologias de informação e comunicação, esses objetos virtuais são exemplos de interfaces dinâmicas que captam comandos e os executam. Na lógica do consumidor, são o que parecem ser ferramentas mais ou menos criativas e funcionais, mais ou menos agradáveis ao olhar, mais ou menos fáceis de compreender e usar. Se fossem físicas, certamente seriam protegidos pelos direitos de desenho industrial. Sendo virtuais, também devem sê-lo.
Para debater essas questões, teremos neste painel um time de especialistas nos impactos da transformação digital, moderado pelo nosso diretor conselheiro, Ricardo Boquim.
Olá, bom dia. Desculpe aí pelos problemas técnicos, alheios à nossa vontade. Infelizmente, esse mundo virtual, traz benefícios, como ter aqui, por exemplo, nesse painel, palestrantes da Ásia, da América do Sul, América do Norte e Europa, mas a gente também sofre, às vezes, com os problemas técnicos. Mas, para não tomar muito tempo, eu vou fazer uma abertura muito rápida. Nós temos aqui especialistas que são professores em universidades e palestrantes que falam sobre esse assunto de interfaces gráficas. E a ideia é entender
graphical interfaces. The idea here is to understand how other areas address graphical interfaces, especially the dynamic graphical interface, which is not part of our industrial design manual in Brazil. We'll also have the examiner from the ABPI talking about practice in Brazil. To kick off the panel, I'll give the floor to Tracy Durkin, Director of the North American Law Office, Stern, Kessler, Goldstein & Fox. She's the leader of the Mechanics and Design Office, talking about the practice in the U.S. about dynamic graphical interfaces. Thank you all. Tracy, you have the floor.
Thank you. It's a pleasure to be here with everyone today. It's an honor to be on such a distinguished panel and talking about such an interesting topic. So, as I think everyone knows that the world of user interface is really booming. We can now choose between more than 2 million apps in the Apple App Store and Google Play Store each. And the need to protect this new innovation is becoming more and more acute, particularly because it's harder and harder to protect software development with utility patents. And so people are turning to design patents more often in order to protect these important developments. So in the United States, design patents have become the fastest growing asset to protect both icons and graphical user interface. They make up nearly 6% of all design patents that have issued to date. And it's the fastest growing area in the US Patent and Trademark Office in terms of the number of applications and examiners. So for example, when I filed my first design patent application in the US for a graphical user interface in 2007, There was one examiner examining them. There are now more than 20. And the reason for that is not surprising. The companies that you would typically think of are certainly making up a large percentage of the filings for graphical user interface design patents. It's Microsoft, Samsung, Apple, Google. But you might be surprised to find out that many, many other companies that you wouldn't normally think of in the software industry are also filing for design patents for graphical user interface. And it's consumer product companies, automobile companies, banks, companies that are not really in the business of generating software, but they are doing so in order for consumers to interface with a computer, either when they're purchasing the product or when they're using the product. And so this really accounts for a lot of the growth. In the United States, we have, as in most countries, utility and design patents. Utility patents, as you know, protect the way things work. Design patents protect the way things look. In the US, our design patent term is 15 years. There's no extensions beyond that. Patents are examined, design patents are examined for novelty and non-obviousness. So we have substantive examination in the US. Utility patents protect things that are useful. Design patents protect things that are ornamental. But the two are not mutually exclusive. And so here's an example of where on the left, I have a utility patent claim and the drawing, a drawing from the utility patent showing the slide to unlock feature of the original iPhone user interface. And then on the right-hand side, I'm showing you two different design patents that show how that concept was implemented on the phone. One is the line drawing there, the other is a digital image, and I'll explain in a minute why you might do one or the other. So in the US, we have an article of manufacture requirement, meaning that you can only get a design patent for a design that is applied to an article of manufacture. And here's just two examples of in the hardware space, what an article of manufacture might look like. But in order to protect graphical user interface designs, we had to have some sort of article of manufacture. This is a famous case going back to 1992 that actually allowed the use of broken lines to show the article of manufacture as a way to satisfy the statutory requirement that there be an article. And so this is how our law has moved forward in the US, at least up until now, that the original filing in the application just had this icon. During prosecution, they added this broken line computer screen. While this patent was not allowed because adding that computer was considered to be new matter, this case basically paved the way for future applications for graphical user interface. So let me show you some examples so you can see how this is working in the US. So when I look at protection of a graphical user interface, application development, for example, I start with the icon because that usually is the gateway into the application. And so here's an example. This is a single patent in the United States where actually two designs were allowed in the same application. One is color, one is grayscale. And you can typically do that in the US. Here's another example of an icon. This is actually two different patents. In the US, it's typically not possible to patent a digital image and a line drawing in the same patent. And that's because you can see the design on the left has a lot more to it in terms of the color and the tonal differences. And so when you present two designs in the US in a single design application, and the office considers them to be patentably distinct, then you can't keep them together. And so here's an example of where it's really the same underlying design, but protected two different ways. Here's another example of sort of the next level that I look at is the screen layout. And here's three examples of really the same design protecting it three different ways. And so on the left-hand side, you can see this is a digital image of the original menu page of the Apple iPhone. In the middle, we've created just a line drawing of that. So different scope. These are allowed to be patented separately in the US. They wouldn't be allowed together. And then on the far right, I'm showing you just the layout. So the design of the icons, for example, is not important. And so they're not shown here, although they could have been shown in the US in broken lines on the phone. But it's just showing how you might approach a single design in different ways for different scope. Animations are really where we're seeing a lot of development today, and that can easily be protected in the United States. Here's an example of a very early animated design patent for an animated design. You might remember when the iPhone first came out, one of the really interesting features, because we had gone from having buttons on our phone to all of a sudden interfacing with just a screen, was making sure you were hitting the right key on the keyboard. And so if you look really closely in these images, the only thing in the claim of figure 1 or the drawing of figure 1 that's in solid lines is the little rectangle in the middle of the keyboard. And then you can see in figure 2 where that key has expanded, so you know that you're hitting the right key. In the US, we have partial design. So that allows us to show the environment that the graphical user interface is taking place in without having to claim all of that. Here's another example of an animated design. And really an animated design is any design that is shown in more than one figure. And so this one has 5 figures, and it's showing how this light feature sort of swirls around. Of course, the more figures you have in an animated design, the harder it is probably to challenge it on validity, because it has more to it. The flip side of that is the more figures there are, maybe the easier it is for someone to design around it. So perhaps the scope is more narrow with more figures. So you have to sort of balance, how many figures do I want to include? I typically have 3 or 5. It seems like odd numbers seem to work the best. In the United States, we can also patent groups or sets of designs. And so you might have something that isn't necessarily an animation. It may not always be appearing on the screen at the same time, but it's sort of a set of options that a user might see. And so here's 3 different examples of how you might patent something like that. In the US, we often require a bracket or some sort of element here that shows that these are actually in a group. But that's another thing to think about. Otherwise, you might have to have, for example, on the left, 3 different designs, 3 separate design patents to protect all 3 of these. So by calling them a group, we can include them all in one design patent. Fonts or typefaces are also protectable by design patent in the US. Interestingly, the very first design patent in the United States was for a font. So this practice goes back quite a long way. And you can see on the left, the design patent here is a very traditional, what you might consider a traditional font. The one on the right, however, is really where, where communication is moving to emojis and memojis and things like that. And so those are also protectable. You notice the fonts don't require the broken line that you've seen in some of the other drawings where, from that case I told you about, we're required to put a broken line around the design. Fonts have always had an exception of not having to show the article of manufacture in the US. One of the other big areas that I think is really happening in the development of graphical user interface are what I call visual effects. So it's not necessarily the underlying design that's interesting, but it's how it's being presented to the user. And so here's an example. You might remember when Control Center first was available on your iPhone, that there was this translucent layer that you would see as the Control Center was being launched on your phone. And so here in the US, we're allowed to do some really interesting things with drawings. And so by showing this stippling layer here, and you can see in the description, we're saying that the stippling in the last paragraph here portrays the illusion of a translucent portion of the graphical user interface. And so we're not really claiming any of the content here. We're just claiming, and in fact, I'll go to the next slide, This is actually an animated design with 4 figures, and it's actually showing how the control center layer is going down on the screen, and through the translucency, you can see this sort of gray colored box. Again, we're not claiming the box, and we're not claiming the color gray. We're just claiming this translucent layer. One of the other areas where you see a transitioning design is where maybe a design starts on one device, but then is displayed on another. And so here's an example of a design that starts on your phone, but then when you get to your computer, you can take over control of the design, and the same design is then presented there. And so in this particular case, it's a 3-figure animation, but we had to specifically say, you can see the claim at the bottom there, that the ornamental design is for a pair of display screens with an animated graphical user interface, one being on the phone, the other being on the computer. Another thing to think about is, do you want to protect some of the hardware and some of the software? It may be that the copier isn't copying the software exactly, and they may not be copying the hardware exactly, and maybe because we have partial design practice in the US where we can unclaim certain features and broken lines, maybe you want to claim, in this case, just the outline of the housing of the watch with the crown and just the hands of the graphical user interface. And that way, if someone makes a different band, obviously, or other features that are different, perhaps you have enough scope here to protect them. So a combination can be kind of an interesting design as well. I thought it would be interesting to look at what an infringement looks like of a graphical user interface in the US. We don't have a lot of cases on this, and in fact, globally, there are not a lot of cases on design patent infringement of a graphical user interface. But here's probably, this is where it all starts. Our case on infringement of a design patent goes back to a US Supreme Court case from 1871 involving flatware. That's the last time our Supreme Court has spoken on the issue of design patent infringement. You might remember the Apple-Samsung case went to our US Supreme Court in 2016, but that was on an issue of damages, not on infringement or validity of the patent. And so you can see here, this actually, there was a finding of infringement and an affirmation by the Supreme Court. The handle here on the left is the patented design. The 2 on the right are examples of the infringing design. They actually had their own patent, which is obviously not a defense to infringement because it didn't work here. And the court found that despite the differences, because there are clearly visible differences between the 2, the court found that there was infringement. So with that as our starting point, let's look at the most famous case there has been so far. Frankly, it's the only case where we've had a judgment on design patent infringement for a graphical user interface. It's the Apple-Samsung case. It was a jury decision, not a decision by the court. And in this case, in 2012, the jury determined that the design patent on the left was infringed by the design on the right. Now, you can look at this and see a lot of differences, but what you have to keep in mind is that design patent infringement is looked at in the eye of the prior art. You have to, it's in the eye of an ordinary observer, but keeping in mind what's in the prior art. And it's hard to remember now, but at the time the iPhone first came out, icons typically took the shape of the design that they were representing. So if it was a trash can, the icon looked like a trash can. This was Apple was really the first to make the icons similar in size and appearance. You also didn't have this black background or this dock on the bottom. And so, the Samsung phone, at least in the eyes of the jury, thought that it was similar enough for infringement. We had a second case that followed the Apple-Samsung case in 2015, but it was a case where the parties agreed there was infringement and they only went to trial on the issue of damages. So there's not really much to say there, but that is all we really have in terms of what an infringement of a graphical user interface looks like in the United States. But we're really here to talk about what's next. And what's next, as was really well described in the introduction, are things like augmented reality, where you're seeing a little bit of reality and a little bit of something that isn't really there. And so, for example, Pokemon Go is a great example of augmented reality, where through your phone, you're seeing what the camera sees, but it's being augmented by other things that are not really there. So the question becomes, how do you protect that in a design patent drawing? In the United States, we have to have that article of manufacture. So we have to have something that we're displaying it on. In this case, it's a car display. But then how do you represent the dynamic things that are constantly changing in your environment, and position that in terms of the augmented reality that's appearing there? Well, in the United States, we can use broken lines to show things like the car in the background, so that it's not really part of the claim. And then we would really only be claiming the augmented part of this. It becomes a little bit more challenging when you have virtual reality, because with virtual reality, you don't even have a display screen. The user is just immersed in this non-physical world through use of a headset. And you can also have this combination of the two, but I think what makes the virtual reality environment so challenging is because, again, there is no display screen. The way the virtual reality really works is the images are being projected on your eyeballs. So what's the article of manufacture? We can't claim our eyeballs. And so we have to find a way to get around that in the US. And so I will show you some examples in a minute of how we do that. But again, this presents some challenges in terms of patent drawings, because in the US, we can't just claim the design alone. We have to claim it in the context of a display screen. And so here's a couple of examples of some patents that have issued. The title of this patent you can see here is a display panel with a transitional augmented reality. So it's an animated design. If you look really closely, the only thing that's in solid lines in this patent are these dots that are on the floor. The whole environment is shown in broken lines. And again, we have an advantage here in the US that we can do that, so that if the environment is not tables and chairs, it's something else, we're not limiting the scope of the patent to that. Here's another example. This one actually doesn't have any background. It's a dynamic graphical user interface where the panels that the user is seeing are spinning. Again, we can use broken lines to show that content is not actually being claimed on the panels. And here's another recent patent. This one actually is...
Aqui temos uma outra patente recente.
Is actually a headset.
Que temos esse headset.
Oops. It's a headset design. This is a Microsoft patent where they're actually claiming what the user sees in the headset. And then other countries have been doing this for a long time. Here's just a couple of examples of how this is done. In Japan, they actually are claiming the headset design completely here, and the smartphone kind of over there on the side, just as some other examples. But really the challenge in the US, and I'll end with this, is what happens when the design is not projected on a display. And so the design on the left is an actual keyboard, a projected keyboard that you can buy right now on Amazon. And you can put it anywhere and type, basically on a table or desk or wherever it is. In the US, we don't want to claim the table because that's not really part of the design. Sure, we could show it in broken lines, but what happens when that same design is being projected on the dashboard of your car or somewhere else? We don't want to be limited to a particular piece of hardware. And so other countries are way ahead of the US in terms of allowing designs that are not tied to the hardware. Hopefully we'll see that change in the US coming soon. And with that, I will turn it over to the next speaker. Thank you.
Tracy, thank you so much for your presentation. It was wonderful to see what is ahead of us in terms of industrial design. Sometimes we're discussing dotted lines, so we're thinking of something greater about the virtual world, the virtual reality. So I think that there is a lot to be developed and a lot to be done in order to harmonize legislations around the world. And to speak about harmonizing legislations, we'll move now to our next lecturer, who is David Muscat, who is a consultant of the British office, Marshall Jenkins. He is responsible for design there. He's a design consultant, and he's a professor of international design law at the Queen Mary University of London. So David now has the floor to make his presentation.
Thank you very much, Ricardo. And in some ways, I'm going to pick up where Tracy left off. So the legal basis of our current practice in Europe for protecting screen displays rests on the definition of what a design is, what a protectable design is. So, as Tracy said, designs, generally speaking, are the look of an article. In the European statute, that's expressed as the appearance of the whole or a part of a product, resulting from the features of, and then there's a list of exemplary features of the product itself and or its ornamentation. So the words or a part there, part of the product, put our practice on so-called partial designs on a statutory basis. This isn't a question of argument or interpretation. It's right there in the statute that if you want to protect the appearance of just a part of a product, you can do it. And then we come to what a product is. That's defined in the statute as any industrial or handicraft item. And up to that point, you're thinking, well, you know, it's a three-dimensional thing like a computer or a mobile phone or a screen display. But the definition goes on to include a list of examples, which include graphic symbols and typographic typefaces. You saw some examples of typefaces in Tracy's presentation, and in the US, as I understand from Tracy, you don't have to include the rest of the surrounding product when you're representing a typeface. And likewise in Europe, it's the typeface itself that's the product, actually. And a graphic symbol is not the kind of product you can hold in your hand or throw to somebody or take home from a shop. It's a picture or perhaps some text. But of course, you can trade in graphic symbols. You can buy and sell graphic symbols on their own or as part of a program. So graphic symbols are products in their own right in Europe. So there are two ways of looking at how to protect graphical user interface elements in Europe. You can either go down the same route as Tracy's referred to in the US, where you regard the product as being the computer or the phone or the screen, and the graphical user interface as being the design of part of that product. In other words, a bit of the design or the whole of the design of the screen of that product. And you can show, therefore, the computer or the mobile phone in dashed lines with the GUI, that's the elements that are the subject of protection, in solid lines or otherwise represented. Or alternatively, you can regard the product as being the graphic symbol in which case there's no need to represent a computer. Your product is the graphic symbol and your design is the design of that graphic symbol. So all you have to show is the graphical element that you want. Now, Europe is a little bit unusual in this practice at present, but it may be that at least in the field of electronic products, we'll see wider adoption of something like this approach in future. At present, it's just worth bearing in mind, however, that you have these different options when you're going forward in Europe. And for Europeans, we have to bear in mind that when you get outside of Europe, you don't, and you may have to think about adding in a picture of a computer or a phone around the outside of the design that you're really interested in. So what kind of product classification, what kind of indication of product should we use? The natural place in the Locarno classification, the International Classification of Goods, is class 14, subclass 4, which was created a couple of years ago in the 8th edition, specifically for screen displays and icons. And within that, the listing of products includes graphical user interfaces and icons. So that's the natural place to put an icon or a GUI as a whole or other screen elements. But the alternative is to look to Locarno Class 32, again created fairly recently, which is created for graphic symbols, logos, surface patterns, and ornamentation. In other words, things that sit on their own. And at least in Europe, some of the things included in that class are graphic designs, two-dimensional graphic symbols, and graphic symbol bracket comic figures close bracket. If you have the time sometime, it's interesting to do a search in the EU IPO database using terms like cartoon character or comic figure, because you will find, going right back to the beginning of the system, I found one file within the first month of the community design system back in April 2003, a set of images, the front, the side, the other side, the back, top, bottom, as you would for a solid article, but it's described as a cartoon character, which of course is not a solid article at all. That is a representation, whether on a magazine, two-dimensional magazine, or a two-dimensional screen, of a single character which can be posed and manipulated into various different configurations. So I want to mention that, draw that out explicitly, because for gaming and other virtual world applications where you have the equivalent of three-dimensional shapes, but virtually on your screen, that's generally how we approach it in Europe. We file a representation as we would for a solid object, but class it as a graphic symbol, as a cartoon symbol, cartoon character, and put it in class 32. So those are the places where you find these things. I may be wrong, but I think this is the first animated GUI element filed in the European IPO. And I have an interest because I filed it, and it's filed within the first month of operation of EU IPO in April 2003. I can't find anything earlier. I might not have been the first, but I think I probably am. So let me just run you through the images here, and you can see what it does. It defocuses or refocuses. So it's a male icon, but instead of being a typical male icon, which would have maybe two states, one when it's just on your screen and the other one when you click on it, this one goes through a transformation. And we weren't too sure how to file this in those days, but we filed it in two separate designs in class 1402, which in those days was the precursor of 1404, and we described the object, the product as screen displays. So the first 6 images are in the first design, and they show the male icon blurring out, and then the second 6 are in the second design, and they show it coming back into focus, which are the 2 operations that icon performs. And the reason we did it that way was because there's a limit at the EU IPO of 7 images per design that you file. So we didn't have the option of putting all 12 in one, but it broke nicely into 2 sets of 6. And as Tracy says, very often you can represent a transforming icon in that relatively small number of key images, because it's not like a movie where you're going to sit all day and watch it. It's something that happens, in a second or so, maybe 2 seconds. You don't want to keep the user waiting too long. So user interface elements very often work in a short time scale, and limited number of images will do. In Europe, we have, as well as the EU level system, we also have national design registration systems, and the national systems don't have an imposed 7 image limit. But in fact, many national offices use the same software as EU IPO. And so for practical purposes, we do often have that 7 image limit. If you want to avoid it in getting protection in Europe, you may wish to use the international design route, where they are smart enough to charge you per extra image rather than simply tell you you can't file them. I had a little look to see how many animated GUI elements there are on EU IPO's database. Within class 1404, which is where the animated GUI elements mostly are, putting in the keyword animated brings up about 3,500. And the names you see there, and indeed even the order you see them in, of the big filers are pretty much the same as what Tracy showed you. So 400 for Microsoft, 300 for Apple and Google, 200 for Samsung, 27 for Facebook, 7 for Huawei. I didn't check everybody, but those are some of the major names. These things aren't all in that class, and the word animated may not have pulled all of them out. So some of the older ones may be in 1402, 32 or 99. So you shouldn't regard that as necessarily a reliable or exhaustive search, but nonetheless it's indicative, I think, of the pretty large number of these things that are being filed in the EU. How do we represent these things these days? Well, we now have in the EU IPO manual rather design guidelines, rather extensive guidance. And there is also a collaborative venture between all of the European national offices and EU IPO called the Trademark and Design Network. In fact, it goes a little bit broader than Europe, so Turkey is included. So they have a common practice called CP6, which is, as no surprise, the same as the EU IPO practice. So the images I'm going to show you here are the recommended practice images from the CP6 and EU IPO manual. So an animated design is represented by a sequence of snapshots, a short sequence of views used to show a single animated design at different specific moments in time in a clearly understandable progression. I have always thought it's a good idea, as well as showing the images, to include a brief description stating the order that they go in case the office managed to mess up the order. And this used to happen a lot in the early days. The timings are usually pretty unimportant unless they're, not linearly spaced timings. If there's something non-linear about the timing, you might even want to indicate the timing. The requirements of the office are that the images need to be visually related, and so you don't want to have them so separated in time that they're completely different. You want to show an understandable progression, and you have to number them in a way to give a clear perception of the movement. So here's the first one, and as Tracy said, a number of these images are not filed by conventional software companies. This one's filed by Nike, and I guess it's intended to show you something blazing, catching fire in a circle or something like that. I'm not familiar with the real life thing, but you can see how the sort of fire catches on the left and progresses on round. This is from Deutsche Telekom, and it's another animated mail icon. You can see it's a pseudo three-dimensional thing where the envelope is actually closing itself, unfolding itself as you go through the sequence. I'm not sure what's happened. Oh, okay, there we go. That's the Hoffman-LaRoche thing, where circle after circle is concentrically added. And frankly, no idea what Sony are trying to show us in this one, but there it is. It's a recommended practice of some kind. So if what you have is a visually distinctive image, which changes over a shortish period of time in a predictable way, moves or transforms, the EUIPO system with its 7 images gives you a reasonable basis for working. It doesn't enable you to deal with anything long or complex because 7 images are just not enough. On the other hand, with only a small number of images, if you've got something that's only in 2 states, you might ask, well, why do I need to represent the motion anyway? I mean, if the images themselves are distinctive, maybe the stop frames are enough. Maybe individually the frames are enough. It's really if there's something special about the motion itself or the transformation itself that you need to try to represent it as a moving or dynamic icon. So here is something which, something filed by Google, and it's an interesting challenge to ask ourselves what they are trying to protect here, because you can see the outline, a square outline, but it's in dashed lines. So I'm not sure if it's a screen or a little bit of a screen or what. Then you've got inside that a picture of a man with spectacles, but that's all in dashed lines too. So is it meant to tell us that there's a man there, but it could be any man? Or is it meant to tell us that there's some image there? Or is it just meant to indicate that there could be some image there? Probably the latter. Then you have a rectangle with wanna do lunch and somebody's name, but that too is all in dashed lines. So you probably have to conclude that the text is also optional. I mean, in Europe, anytime we have linguistics in a thing, we tend to represent that in dashed lines anyway, because we have something like 26 languages in the EU. So writing everything in English just does not work for us anyway. Pretty much everything in this is in dashed lines is the issue here, except for the little rectangle. And the little rectangle moves off to the side through these 4 sequences. And also the sequence gets darker. You can see, I think, the dashed line person through the rectangle, so you understand that the rectangle is a bit transparent. So that's what you seem to have, is a linearly moving transparent rectangle with something on it, or possibly not, over an image of something, or possibly not, that's getting darker. What the courts would make of this, I don't know, because there is a point of view that if the design is the appearance of a product, you kind of have to specify what that appearance is. And if what you're trying to claim is, in fact, an image that gets darker and moves, I think you're in the territory of what we would say in copyright terms is the idea, not the expression there. It might well be something inventive, clever, original, but maybe not specific enough to be protectable under what we currently understand to be design law, not because it moves, but because it does nothing but move. There are no other elements specifically and definitely there. But I could be wrong about what Google intended here. So something about the formats we use. At the moment, EUIPO only accepts still images. The manual notes that it is possible to file a 3D model, like a kind of, I've forgotten the name of the software, but there's a kind of CAD software that allows you to show on screen and twist and turn a 3D object. And you can file one of those too, but this is only for illustrative purposes and has no effect on the scope of protection. So it could be useful if your images aren't clear. But of course, it's very hard to generalize one of those. One of the things you saw in Tracy's pictures, slides, and in the slides I've shown you is that the attorneys who prepared these things have done their best to take out irrelevant material, small irrelevant detail, and so on. It's really hard to do that with an actual 3D animated sequence of a real thing. It's there with all the little details and warts and all. National EU offices can accept alternative representations now if they want to. I don't know what they all do, but I can tell you the UK Intellectual Property Office doesn't. But the system is currently under review, and it may well be that this is one of the areas of reform in Europe. We changed our trademark filing system back in 2015, and when we did that, EUIPO allowed the filing, and the national offices allow the filing of short MP4 video clips for trademarks. And I think it's very likely that they'll do the same for designs in future. And the fact that the manuals refer to this and say the technical means are not yet available tells you that this is on their radar. But as I say, with video clips, it's pretty hard to achieve that selection of just the key elements that an attorney often wants to do. I see that the ID5, the international grouping of major design offices, the US, the EUIPO, the Chinese office, the Japanese office, and the Korean office, is also looking into this area. No findings as yet, but I think we can foresee that its changes and expansions will be on the way. Okay, so that is all I have time for. It's going to be a fascinating seminar, and I look forward to hearing the remaining speakers. Thank you very much.
Thank you, Dave. Your presentation and Tracy's brought very interesting examples. I would like to make a comment, by the way. I'd like to remind you that in Brazil, we can protect animated, graphical, or dynamic interfaces through variants. In Brazil, we can have up to 20 variants of the same design and the same application. But the problem is that several dynamic graphical interfaces present large variances between an object and the next in the sequence. And this might lead to issues in Brazil, saying that the variants must have the same visual characteristic that is the predominant feature of appearance. So when one figure varies too much and changes, perhaps it does not maintain the same feature, same fundamental characteristic. This is something we need to address here with the ANPI. So another comment before I give the floor to the next speaker. The example of Casio was very interesting. You have an icon, and then you have a transition to the lack of focus, and then you go back to the good focus. I'd like to admit, and I don't want to put our rep from the INPI in a difficult position, but how would they address here the lack of focus? Would that meet the needs and requirements of the INPI here in Brazil? all legal requirements? I'm not sure. I'm not the speaker, so I'd like to give the floor now to Stephen Yang, our Chinese representative. He is the managing partner of the IP March office with headquarters in Peking. And he is a mechanical engineer. And he'll be talking about graphical interfaces in China. Stephen?
Okay, thank you. Thank you, Ricardo. So I've heard presentations, the two speakers, and I can identify already some differences in practice in China. So I'll jump right into my presentation. For those of you who are not so familiar with the Chinese system, first I want to show you what's available in the patent system. In China, there are three types of patents. Patent for invention, which is sort of the regular patent. In the US, it's called utility patent. It's valid for 20 years. And then we have a utility model patent, which is valid for 10 years, mostly used for protecting mechanical products or systems, products with physical features. But it protects how it works. It doesn't protect how it looks. Design patent, like in the US, it's called design patent. It protects how a product looks, and it's valid for 10 years. All of the patent terms are counted from the filing date. Actually, the Chinese patent system evolves very fast. Every few months or a year at most, there are some changes either in the law or in guidelines of the examination that make our job interesting. It changes so fast that it makes my presentation a little bit outdated already, because the Chinese patent law, the fourth amendment to the Chinese patent law was approved on the weekend 5 days ago, right after I finished my presentation. So I said here, the draft fourth amendment of the patent law proposed to extend the term of design patent to 15 years. Now this is firm. It's not a draft fourth amendment. It is the fourth amendment, which will take effect on June 1st, 2021. So next year, in about 8 months, 7.5 months, we're going to have a new law. And in the new law, the design patent term will be 15 years. Some basic about the prosecution of design applications. In China, we are using an absolute novelty standard, but we do have a 6 months grace period. Not like in US, there's 1 year. In China, it's only 6 months, but it's only available for limited scenarios, so it's not that useful. You have to meet certain conditions to be able to take advantage of the grace period. So don't rely on it. Just pretend it doesn't exist. And voluntary amendment, after you file your application, you can do voluntary amendment for a limited, there are a limited number of opportunities. For design patent applications, you have 2 months from filing date to amend your design application. But in China, the standard of making amendment is very strict. For design applications, there is no substantive examination, but it's not a simple registration system either. You'll get a lot of difficulties, actually, sometimes when you're trying to prosecute a design patent application, because they have very strict rules about how drawings should be made. They have rules of what the title is, what can be put in a brief explanation, which will be accompanying your drawings and form an indispensable part of your application. So they examine all that. So it's not a simple registration system either. The average pendency in China for a design patent application is 3.2 months. This is pretty fast, and this figure was released earlier this year on a press conference held by the Chinese Intellectual Property Office. Now it's called CNIPA, China National IP Administration, China. And look at the number of filings received by the Chinese Patent Office. This is only for design. The blue bars represent the design applications filed by Chinese, and the red bars represent the design applications filed by foreign applicants. You see the gap is huge. Most of these Chinese applications, design applications, will easily meet the Chinese design practice requirements, but many of the foreign, the incoming applications, because they probably have a claim of priority, they were trying to meet the different standards in different countries, they don't necessarily meet the requirement in the Chinese office. So the pendency may be longer, longer than 3.2 months. There's some strict requirement on drawings. If you ask me what are the requirements on drawings, and you haven't filed any design applications, no priority claimed, I will tell you 6 direct views. So, but is it really required? Not necessarily. If you already filed your EU application or US application and you try to work out something here in China, it is possible. You don't really have to have 6 direct views, but there must be something for us to work on. Ideally, 6 views, and the views must correspond to one another. So you can basically assume that the examiners are requiring your drawings to be made by a mechanical drawing making standard. So let's say there's a protrusion in a product in one view, in the same state is visible in another view, you should show that. Many of the draftsmen don't have mechanical background, so they don't understand this. Make sure they do. Currently, there's no shading allowed, and no changes on that topic. No dotted lines are allowed in the drawings, but that's going to change because the 4th Amendment of the patent law allows partial design, which is a great progress from a practitioner's perspective, because that's going to make protection of design, scope of protection of design patents in China broader, and they're make it more flexible for applicants to find different ways of protecting the designs, more user-friendly. But currently it is not allowed. This will be allowed only after June 1st, 2021. So currently what we're doing is if we receive drawings that, let's say, coming from US that have dotted lines, what we do is we first look at whether, if I remove the dotted lines, the remaining part is a separate product. If it's a separate product, then I will file them, remove the dotted lines. If it's not, I will make everything solid, and then I will keep the original drawings with the dotted lines, and I call them reference views, and I try to claim that the main design parts lies in the solid line in the reference views. But that's the best we can do at the moment. We don't have to worry about that when the law changes next year. In one application in China, you can put up to 10 similar designs. But for each design and for the total number of drawings, there is no limit. I think I filed an application that have 50 drawings, 50, and that's okay. So there's no 7 view requirement, limit. In China, you can file line drawings, you can use photographs, or you can use software rendered drawings. Any of these are acceptable, but do not mix them. That's not allowed. Coming to design protection for GUI, graphic user interface, before May 2014, this was not possible. And the reason for that is any design only visible in a power on state are not subject matters that can be protected by design patent in China. But because the Chinese companies, a lot of software companies, IT companies were pushing that, so the guidelines for examination changed on that date, make it possible for protection of GUI with design patent. So, but the Chinese practice is strict and limited in terms of protecting GUI from that date. It still, there's like the article of manufacturer requirement in the US, a design still must protect a product. It does not protect the GUI itself. So a GUI can be used on a phone, on a computer, but you have to protect the phone and the computer. So protection of the GUI itself independent of the product is not possible. But after a few years, in November 2019, the guidelines changed a little bit, make it easier to protect GUI itself. Now it's the current standard is you can protect the display screen panel, which shows the GUI with the GUI. So basically, you still have to protect a physical product, which is the panel, the screen, with the GUI on it, but you don't have to show the whole product with the panel. But unlike in the US and in Dave's case, in China, it's not possible to protect an icon itself. In fact, there are other things that are excluded. Even if GUI is protectable by design, it says here, game interface and patterns displayed by a displaying device of a product, which patterns are not relevant to human-computer interaction, such as wallpaper on an electronic screen, picture shown during the start and shutdown of a device, or graphic layout of web pages, which is not relevant to human-computer interaction. None of these can be protected by a design patent. Again, there are some requirements, formality requirements, and I'm going to go through them, then I'll give you some examples. First, the title for design for graphic user interface design applications must have the word graphic user interface in Chinese. If it's dynamic, it's with animation, it must have the word dynamic. And the title must include the name of the product having the GUI and the use of the GUI. For example, the title can be a refrigerator with temperature control GUI, a weather forecast dynamic GUI of mobile phone, displayed screen panel with video on demand graphic user interface. Generic names like software graphic user interface, operating system graphic user interface are not acceptable. Regarding the drawings for graphic user interface design applications, if the design point is only in the GUI, then at least one direct view of the screen panel containing the GUI is required. If you want to show, like in the refrigerator case, you want to show the refrigerator with a GUI, you want to show where it is and how big it is in proportion to the refrigerator, you need to file at least one view with of the side of the refrigerator that has the GUI on it. This is already a loosened requirement. In the past, you have to show 6 views of the whole refrigerator, but now you don't have to. I guess when the partial design passes, the requirement will be even more flexible. And in some cases, you're trying to protect the GUI of a projector. I can assume in maybe virtual reality, you could do it in a similar way. You can file the views of the GUI itself, plus at least one view of the projector. And in the future, probably you don't even need to show the projector in solid lines. You can use it in with dotted lines when the partial design requirement, when the partial design practice is allowed next year. For animation graphic user interface, at least a view of the site showing one state of the GUI is required. So you have to designate one view as the main view. And for other states, you must show the key frames of the animation. And the way you show the animation is that you must be uniquely determining the complete change process of the animation in the dynamic pattern. It's easy to say than done. Actually, the examples I'm going to show you, some of them are clear, some of them are not that clear, but they're allowed already. I will show you in a minute. And in the application, you should mark the number of these views, and so people can see how it progresses. So this example, I believe, is filed by Google before November 1st, 2019. And that's why they're finding a drawing of a mobile phone. After November 2019, it was not necessary. All they need to do is show one picture of the phone, or not even one picture of the phone, but just the display, just call the subject as a display panel. That will be fine. And then they show the user interface. So you can see it moves from one block, the user interface, and then there's a bubble, and it becomes bigger and bigger, and it squeezes the square to the right, and then it becomes two squares, two blocks. So this drawing shows how the interface changes. Next example, this is for a user interface shown when you play music on your phone. And this, by the way, this Google application, these are all the drawings they file. And in this music playback user interface, these are all the drawings they file in that application. As you can see, the first row here, these are showing how this circle is changing. It shows a wave. And when the sound gets louder, the wave gets bigger. But because it's continuously changing, there's no way that you can actually present exactly how it changes with only 6 views. But I guess this is as far as that they can do. And they didn't show, inside a circle is a picture, and it's a picture related to a particular song. So the main views here and the change state views didn't show what's in the picture. It can be omitted, and that's allowed. The best practice would be you show some examples. And this is the second row here are the examples that was shown in the design application. So next one. Apart from the drawings, in China now, we must file what we call brief explanation to accompany the drawings. And the brief explanation is very useful to make your dynamic GUI applications clear. And clarity is a big thing in the examination of design applications in China. If the examiner thinks this is not clear, it's an easy reason for them to object and even reject your applications. So in the brief explanation, you should state the use of the GUI, was it used, and you should also explain the use of the GUI in the product. You should, yes, so how it works, how it's done in terms of human-computer interaction, how the animation of the GUI changes. All of these you can put in the brief explanation. And the example I'm going to show you clearly meet this standard. One thing to take note is that if your design only has to do with the GUI itself, and the final product of the GUI must be exhaustively listed. That is a very strict rule. So be careful with that. So you want to say that this can be used on a mobile phone, on a computer, on a display in a car, things like that. So make sure you list as many as possible. Here is one example. This is a pretty up-to-date, actually. This is software user interface, and the software is used to track the moving of people in China. Actually, the software is used to track the moving of people from Wuhan to other parts of China. So the first on the upper left, the first picture, the center, which is kind of red pink, is in the Hubei province, and then there are arrows. It's showing the people is moving to other parts of China. The second picture on the upper right is like a blown up view of Hubei province, and then it shows people are moving to Beijing. And then so this is how the interface changes if you pick Beijing, and then this is how it changes. And then the third view on the bottom left is an enlarged view of Beijing, the administrative geographic area. And then if you put your mouse on some areas, that brings you to the next view, which shows how many people are moving in from Hubei province. And all of these that I'm explaining to you, you need to put them in a brief explanation. And I can imagine that this software can do a lot of things, and there are other things in the software, and the user interface may be different, but these 4 views are the only views that were put in this application. So my point is, if you have a software that has multiple functions, don't put them in one application, because that's going to limit your scope of protection. If the other functions have totally different type of graphic user interface, if they're similar, you can put it in one application. If they're different enough, file a separate application. And this is best shown in the next example. By the way, this is filed by Baidu in China, the equivalent of Google. This one is also filed by Baidu. This is an onboard computer. They call it onboard computer. This is also filed before November 1st, 2019. So they call it onboard computer. But if they filed after that, they could call it a display screen panel. It shows how you control the headlight, the light patterns of a car. You can see there's a limited number of buttons. Some of them control the car, the light. Some of them control the air conditioning. But these 2 views are the only views they filed in this application. So I guess for a graphic user interface that used to control the air conditioning must look quite different. So that's the reason they didn't include that in this application. And that's a very good example of how you can broaden your scope of protection as much as possible. And this is another example. This is something that is very used very common these days. This is a navigation system software. Again, this is filed by Baidu. I did a quick check. They filed hundreds of applications in recent years for GUI and dynamic GUI. This is a good example of showing you what you can omit in an application. As you can see, the top 2 views are what they call the main view and the change state view. again, these 4 views were the only views they filed in this application. And the bottom 2 show the actual use of these graphic user interface. As I mentioned, we cannot protect an icon, but we can protect an icon in the environment of a graphic user interface. So the first 2, the only thing changes is the state of the icon. One, so what is this icon used is to show you your distance, to the change point, maneuvering point. That's what they call it. Let's say you need to make a left turn here. So the first icon shows you, you have a lot of distance to go, and the second one shows you it's getting closer. So this is all they do, and this is all they're trying to protect. And you don't need to show the background and a lot of other information, just need to show the main parts. So the takeaway here is, at the moment, we need to file application for the display panel only. Don't really have to file the refrigerator or other things unless you really want to do that. But in the future, we may be able to protect the GUI itself because partial design is allowed. But even if partial design is allowed, there's still article of manufacture requirements in China. I suspect this will not go away in China. So even if you can disclaim part of it, you still have to show what this graphic user interface is used on. Let's say if it's a computer or it's a panel, or there has to be some kind of physical product attached to it. And graphic user interface for dynamic ones or non-dynamic ones, it's very likely they have multiple functions. So try to group them into different categories and file them in separate applications. If they look very different, definitely you should file them in separate applications. And you don't really have to show everything shown on a graphic interface, only the key things. So omit those in your drawings and put them in reference views so people can see it more clearly. But those reference views don't really form part of the protection. So you're not limiting yourself by putting in the reference views. And because of complexity of dynamic graphic user interface, use the brief explanation to describe how it works. So with that, I conclude my presentation. Thank you.
It's been a wonderful opportunity to understand how the practice is evolving in different jurisdictions, including in China. Several amendments are being made that will protect partial protection over design. I will move to our our last lecturer, who is at the other side of the table. I'm going to give the floor to Flavio Alcantara, who is the head of the technical examination and 3D trademarks of INPI, that is going to give us an idea of INPI, how the INPI sees graphic interface. You have the floor. Thank you very much, Ricardo. It is an honor to be part of this presentation. It is actually a unique opportunity of having so much valuable information and different views of industrial design and graphic interface. The INPI is grateful to ABPI, and we would like to thank them through Ricardo. So we're going to start talking about the practice of industrial designs and dynamic graphic user interfaces in Brazil. Throughout this panel, we've had a lot of information about the reason why companies want to protect their GUI. So we have it in software, we have the issue that these interfaces are part of the software look and feel. So consumers can recognize software just by handling this software. They know the product origin just by manipulating or handling these interfaces. And we know that these are products that need a lot of investment. It is not cheap or inexpensive to make a good, attractive interface for consumers, and this adds value. We have consumers that are loyal as a consequence, and the product is more valuable. Nevertheless, we know that there are several challenges when we deal with protecting GUI, and we can list these challenges. They're legal, which are those that pertain to the law. Sometimes because the laws are older ones, they do not allow for the products of new technologies are adequately protected. Another barrier that we end up having, or another challenge, is the procedures laid out by each office of each jurisdiction. So this may end up leading to a difference when we want to protect, depending on the tools that the offices make available, so that people can claim their rights. Furthermore, we have a third point, which is precisely these challenges in different countries. There is a difficulty of harmonizing countries, and there's this idea that this perception that we need to harmonize them. We know when dealing with new technologies, we notice that there are procedures and legal bases which are different than those that people have to overcome in order to go on with their filing. So I've brought here two examples very briefly so that we can check these interfaces and the offices. In the upper example, or in the first example, we have Apple dynamic interface. When a user minimizes a window, we have the genie effect, as it is called, and it is quite characteristic. So if you know Macintosh graphic user interface, you will recognize this when you use the machine. This is user feedback. And further down, we have a Google example about dynamic interface for selecting credit cards in a payment app. So here we have a different perception of dynamic interface, where it is no longer just an answer to a user's action, and it becomes an interaction tool. Users start dragging their fingers, and the dynamic interface follows it. It's part of the user's control. So it is important to stress that dynamic GUI also evolves in time and with its functionalities, not just visually. And this makes it, as of the development of mobile devices, makes them increasingly valuable. It helps changing software control into something increasingly natural for users. And here I bring you a comparison made in a study that has taken as a base some of the information that can be found in ID5, which is a forum made up by the 5 largest industrial design offices. And in this forum, they share practices, they share information. This is very useful if you don't know it yet. I think it is very useful to get to know the practices of the main offices around the world. And then looking at this screen, we realize that amongst the 13 types of protected interfaces in these offices listed here, Brazil protects only 5, as opposed to the EU that protects all of the 13. At least theoretically, the office admits all of the 13 ones in comparison to Korea or the United States, where we have protection of 9 types of interfaces in these two jurisdictions. And we can draw some conclusions from this image, where you see, for instance, that South Korea and the United States, just like Stephen explained, and also China, these jurisdictions, these countries have a restriction on industrial design because it has to come or has to be related to a physical manufactured product. And this is a kind of a restriction that you don't find in the European Union. They consider graphic interface as a product in itself, and there would not be a need for incorporating GUI in the physical product. So this allows the EU to offer greater protection to interfaces like virtual interfaces or augmented reality in an easier fashion. And we should have the same possibility in Brazil, because Brazil does not require that the industrial design is pegged to a physical product. We can do it without demonstrating this. So what we see is that in Brazil, there's still a path to be covered in order to allow these new kinds of interfaces to be protected, as is the case of other jurisdictions. I will now show you a little bit of the current practice in Brazil. I think that this is important, and I think that this is often not clear to all users. And Ricardo alluded to this. Our industrial design manual with our procedures does not mention any kind of specific orientation for interface design filing. So this is something that we have to clarify for users, and I will try to bring you some clarification, those of you watching us, and I hope that I can help people understand the current practice. And after that, I'm going to speak a bit about what we are working with at INPI in our working within industrial design, trademarks, and industrial design in order to improve the situation. So here we have the first challenge: dynamic graphic interface. The greatest challenge when you try to protect dynamic user interface, which is the variation of configuration, which is described in Article 104 of our law. It requires that such variations have a same purpose, and at INPI, we understand that to have the same purpose is to be in the same class and subclass of Locarno. INPI does adopt the International Locarno classification. So when we look into a GUI filing or any other kind of filing, we require that when figures of different designs and different products are presented, they should be in the same Locarno class and subclass. Likewise, they should have the same distinctive characteristic. And this is maybe where our biggest problem lies. And in order to give you an example, I'm going to deal with a Google interface where we have an icon that Google used to use. I think they still do. When you make a voice search, the icon varies according to what the person is saying. And Google presented different figures, 10 figures in this case. And when we were looking into this filing, the examiner looked at the filing and said, well, they're all of the figures with a design with the same purpose. So that's ticked or right. The second criterion, do they all have the same dominant feature? He looks and sees that all of them have more or less the same shapes. So that is approved, and it is a design that can be registered. This is the protection that we grant to industrial design for GUI in Brazil. But it is very important to stress, though, that where you do not have protection is in the case that today we do not offer a protection for the progression in between figures or shapes or pictures. So the progression that is protected by other jurisdictions, according to ANPI, this is not cannot be protected. So what did Google get? It got a register of 10 static pictures that were granted protection, and they do not correspond to a single design of a dynamic interface. We know that these two things are not alike. We have examples that show even more complicated situations for people who are filing. This is a Samsung filing with a dynamic interface of different figures, 7 figures in this case, and the examiner checks if they have the same purpose and the same Locarno classification. That's ticked OK, and then he checks if they would have the same dominant distinctive feature. As you may see, the icon shown in the lower portion of the screen starts as the representation of a small keyboard, and it transitions to a circle. The keyboard decreases and then it grows again to become a circle or a button. So what is the examiner's reading at that point in time? He does not see that these figures have the same dominant feature, and as a result, the filing or the register cannot be granted in this way. So the person filing is oriented to make a subdivided request that would originate from this initial request, and what the person filing would receive, and I go back to what we were saying in the previous interface, he would receive a industrial design with 4 static figures and another one with another 3 static figures. And dynamic industrial design or dynamic GUI was turned into 2 designs of several static figures. And this happens quite often when this kind of demand is made. The person requesting the filing does not comply with this demand, and after the legal period, the request is not granted because it does not satisfy those who are requiring the filing. So this is what ANPI is doing currently regarding dynamic GUI. Another challenge for dynamic GUI, but not only for them, but of any kind of interface or any kind of product, are the disclaimers, which here in Brazil we usually call the dotted lines. These are the lines that do not claim, are not claims of any industrial design. They're there just to provide context to what is being claimed, demonstrating part of a product, or we have different situations. So we have here a Facebook dynamic interface where they have both the device and the interface around the claims. And this is presented in 3 figures. And you should note that they even show where the person places his or her finger. You can see the interaction the user interaction. And then what happens? This request, in order to be accepted, all of the dotted lines have to be removed. And this is a problem because often the play of pictures in the request lose their meaning. So it is difficult to understand what this product is about when you remove it from its context. So in the last procedure change that was made in the first industrial design manual, we incorporated a possibility, which is the person filing, I will go back, should present a play of figures just with the requests, without the dotted lines, without the disclaimers. But he can also complement the play of figures without dotted lines with another play of figures that present this context. In our manual, they are called merely illustrative pictures. So this was something we added in order to try to allow for more meaning. And then these merely illustrative pictures are part of the register. This is something that we have done in order to try to complement our current registration. So I've brought you two examples, only two, but I think that those are the most complicated ones for people requesting industrial protection of GUI in Brazil. But I think that we would have yet other difficulties like restriction to the inclusion of texts in filings or to the inclusion of trademarks. These are all issues that we have, but that are less common. These would be the two main ones. And here I can say that when we talk about challenges to the protection of GUI in Brazil, the main challenges are legal ones. Industrial design should be better defined, more accurately defined, especially regarding surface ornamentation. And this is where graphic design would come into, and especially regarding this visual progression notion. If this would be admitted according to the law. And the second one is what was said about defining the main distinctive features of the design which are required. Furthermore, we have administrative issues which require, which pertain to our industrial design manual. This is something that I believe we need to correct rather quickly, which would be the lack of specific procedures for the different graphic interfaces. And I can even expand this perception in the sense that we would need specific procedures, not just for graphic interfaces, but also for several products that, because of their inherent features, require specific procedures. So to give you an example, maybe an exaggerated one, but that illustrates well, current in industrial design registration in Brazil, we treat in the same manner a print on a t-shirt and a dynamic graphic interface. And this is not beneficial for people filing, and this makes it a lot difficult for examiners too, and for ABPI as a whole, because the process becomes more costly, it's longer to solve these problems because they're more complex. And in a certain way, they are brought about because of the lack of a specific procedure for a given type of products or a given type of industrial designs. Additionally, something that is relatively simple to resolve, and I think that we're in the good path, it's the lack of specific procedures for the use of disclaimers in our own procedure. So just with a brief summary about the origin of filings for interface in Brazil. We have slightly more than 2,000 since the first GUI requested in Brazil, which was in 90 something by IBM. We've had 2,000, and something that was raised in this survey, which I thought was very important, that only 6% of these filings are or originate in Brazil. So there's a major gap, and we have to take this forward by means of a study or maybe get in touch with these companies to try and understand why there is so little intention of protecting industrial design in Brazil, what can be done in order to increase this number. Now, talking a little bit about the reality of industrial design filings in Brazil, we have a number of requests that has been very stable. We had 6,000 requests over the past 10 years. This is increasing quickly, and maybe they will go down because of the COVID pandemic. But in this stable scenario, we have something remarkable, which is a decrease of our backlog. So as of 2015, when we had almost 16,000 pending filings, this went down to 3,400 in 2018. And we can see on the chart that there have been some actions by ANPI itself which explain this, like instruction or directive 914 and the incorporation of more staff, which occurred in 2017 when I joined ANPI as an examiner. So in 2019, we had the launch, another beneficial action for users and examiners, the launch of the first industrial design manual, guiding the examining procedures and filing procedures. So the purpose here was to increase the transparency and the predictability of obtaining these rights. And we can see that from 2017 to 2019, the average time to obtain the decision went down from more than 2.5 years to 3 months. And currently in 2020, if we look at the average every month, we vary between 1.7 and 2 months. So we managed to grant on average up to 2 months later if there are not too many requirements, or provided that the process goes smoothly. So I think that maybe it is important to stress that we work in different projects in order to improve the quality of the examination of industrial design. We have a quality management system. We have the second edition of the industrial design manual and a new IT system in a partnership with WIPO. And we have the intention of adhere to the Hague Agreement, which is something very dear to the head of the NPI. This is something that is already, these are projects that are ongoing in one way or another. Some of them only beginning and others well on the way, like the quality management system. And I would like to stress that this second edition of the manual as a project is very important. So since the second half of 2019, INPI is trying to analyze the feasibility of the protection of different graphic interface types. So these studies are underway under the coordination of the Industrial Design and Geographic Indications Division, because we believe that there is room in order to make progress in this matter. We can progress in this matter, and we believe that this would be beneficial for people filing and for the quality of industrial design in Brazil. And now, just upon closing, I would like to stress something that it is very clear to me, especially about the current division of the trademarks division, the head of which is Mr. Andre Marcus Feli. Our law reads that the request of filing, according to ANPI, will contain, and a list of items is listed. And so we have implemented, INPI and DIRMA have tried to implement better solutions for the protection of these rights in Brazil. And I think that with the change of mind frame and procedures, and there is a mind frame change going on just now, because INPI before would impose conditions so that you would obtain your registration, and now INPI is turning to a perspective where you provide the conditions that this right can be obtained. So I think that it is very clear to me, who am there as an examiner and head of division. I hope that this message is conveyed to people who are filing and those who are listening to us, that you understand that there are good practices from other offices that we are adopting, and although, of course, complying with norms in Brazil and legal safety, we do have room to grow and improve our practices in Brazil. So I close my presentation now, and I hope that this has become a little clearer. There's so much that I would like to speak about, but I give the floor back to Ricardo, and thank you very much for the opportunity for the INPI to explain its work.
Well, thank you, Flavia. Thank you for your kind words. It is quite rewarding to hear these comments and to find that the INPI is sensitive to our needs. We know the INPI has been opening more and more room for applicants to propose changes and send their comments. We're awaiting anxiously for the second issue of the manual for industrial design. It's late now. We had some technical problems, so I will need to close now, but it was certainly an excellent panel. The comments here on the chat were very positive. They were all happy to hear the point of view of different jurisdictions. I'd like to thank you all for your participation, and I do hope to see you soon, preferably with some physical contact.
Já faz algum tempo que falamos da velocidade das transformações do mundo. Mas, na verdade, esperávamos que essas mudanças seguissem um ritmo imposto por nós mesmos, segundo nossas próprias necessidades. Como se as mudanças fossem previsíveis ou fáceis de assimilar.
As if changes were easy to be seen until the world stopped and we had to hear the news and watch face to face her vulnerability or weakness. We did not expect such a situation, but here we are, deep into it. Were we able to learn anything from that? Being able to learn is the main feature of human condition. We needed to overcome our own limitations. And now, what is clearly apparent is what we are. We're part of a large ecosystem, and we are all dependent on one another. The challenge is to learn the new ways of digital transformation, making a difference with courage, empathy, and innovation. It is in that spirit that the LD Soft team is here ready to help you do more and more for your customer, offering the means for you to work with more productivity and efficiency. Even in the unexpected conditions of totally remote work, our tools will offer whatever you need to provide attention to that which only you can do. So you will have time to offer your customers excellent results. So let us go on. And so that we can open up our smiles very soon, celebrating our achievements. LD Soft, potentializing and enforcing the legal universe through technology.